Hey there, welcome back to yet another episode in the journey of demystifying the Patent Act. Over the last few episodes, we identified and discussed various forms which are required to initiate filing of a patent application. One of those forms is Form 2, that is used to disclose information pertaining to the invention, the complete specification or provisional specification. Before we go forward, let's take a pause and recall the entire premise of the patent system. The patent system works on the principle of exchanging information in return of rights, wherein the inventors share the details about their invention with the society at large, benefiting the society, as the information can act as a pathway for further innovation and further advancement. On the other hand, innovators or inventors also receive monopoly rights in return of this exchange. So it's a win-win situation for both the parties. However, the system will work in a fair manner only when right level of information is shared by the inventors. Therefore, in order for the system to work in a manner as expected, the Patent Act has enumerated a set of requirements. We will be discussing about Section 10, which enumerates multiple requirements set out for the purpose of obtaining right level of information from the applicant. Section 10 states that every application for a patent should describe the invention fully and particularly and should start with a title 10.1. So the title should describe or should aim to describe the subject matter of the invention. For instance, a method and system for optimizing battery performance. It should be brief, it should be devoid of any fancy terms, should not have words like patent or inventor's name into it, or anything else which does not make sense or does not help in identifying the subject matter of the invention. And there is a word limit to it. It should be less than 15 words, less than or equal to 15 words. Now, the purpose of specification is to describe the invention. What better than having drawings to describe the invention? Because it always helps to see a system, the components, and the associated specification and description to connect, to visualize the system. There are multiple formal requirements with respect to drawings, such as any drawing or any sketch which requires complex illustration should not be part of the specification. It should be simple line diagrams as such. And any drawings which are filed with the specification becomes part of the specification. Another requirement that is there is most of the times drawings depict method or system components, and these components are usually numbered. Now, when you refer to the same specification or the same component in the specification, the same number should be carried forward through the specification, including the claims. So the numerals should be carried forward through the specification. Interesting fact about drawings is controller can also request you to furnish drawings. There could be scenario where you may not have provided the drawings, or there could be scenario where you have provided the drawings, but the controller is of the opinion that more drawings could help. So in that case, controller may request you to provide more drawings. All sorts of drawings, your drawings, controller's requested drawings also become part of the specification, the bundle that we are talking about. Now, there is this misconception that you need to have a working prototype at the time of filing a patent application, or you need to have a model as you go ahead and file the patent application. There is no such requirement. However, there could be scenarios where controller may be of the opinion that a working prototype or a model may help the controller understand the invention in a better manner. So the controller may ask you to submit such a model, a working model, which can illustrate the invention. Mind you, this will not be part of the specification. This will not be the part of record. Only the specification drawings that you submitted would be part of the invention. So we discussed 10.1 title, drawings, and models. Moving on, Let's go on to specification, the complete description part, which provides the detail about the working of the invention. So section 10.4 is dedicated to the requirements from the detailed description section. As we have discussed multiple times, an application for an invention should describe the invention fully and particularly, and its operation, use, or method of performing. You need to give out all the details. While you do so, there is another requirement for you to provide the best mode of performing the invention. You should not be holding back any information with you. You need to provide how can one use the invention or make the invention or operate the invention at the best of its capability. Remember, you need to provide all the details because in exchange you are getting the rights. So if you hold back some information, the purpose is defeated. Then there is a requirement of claims, that the specification should include claims which clearly define the scope of the protection that the applicant is seeking. We will discuss about the further requirements of the claims because there is another section which is dedicated to claims only. Finally, there is a requirement of an abstract, which is nothing but a concise summary, or so as to say an executive summary, which not only provides the technical field of the invention, but also talks about the technical problem being solved by the invention along with the technical solution. All this needs to be done in the matter of 150 words. Section 10.4. Examiner can amend your abstract if he's of the opinion that it doesn't do justice to the requirement. And every abstract is associated with the figure, a diagram, for a better understanding. Because this is the first view of the invention. Anybody who reads the abstract along with the drawing should be able to know what the invention is talking about. Let's move on to the claims. Now, claims are the most important part of the specification. What are claims? With the claims, we are expressing technical systems and technical method using legal terms for defining the protection, for defining the boundary that we want to play in. As they say, what is not claimed is disclaimed. You have something in the specification, but you have not provided the same in claim, it is not claimed. Others may not be able to claim it, but then you will not be able to enforce it also. So it's out in the public. So if you think something is important, something defines your boundary, it should be part of the claims. Now moving back to the requirement as taught by section 7.1. Every application should be for one invention only. Therefore, every claim should relate to a single invention. In case of multiple inventions, all these multiple inventions should be linked by an innovative concept, a single innovative concept. This is known as the unity of invention. Now, because claims are the most important part of the invention, of the specification which defines the boundary of the invention, they should be written in a clear and succinct manner. Precisely in an accurate manner, they should define the boundary. And finally, they should be fairly based on the subject matter in the specification. So you cannot claim anything or you cannot talk about anything which is not described in the invention. So enabling of the claims. If you write something in the claim, you should describe in the specification. And if you think something is important in the specification, it should be part of the claims. Two-way traffic. So with this, we discussed about the requirements of title, drawing, model, if any, the detailed description, and the claims. Now let's take a use case where the subject matter is a biological material. Now there is this much that you can explain with words or diagrams when we are talking about biological material. And that too, when the biological material is not available in public domain, it's not available to the public. How do you satisfy the requirement of section 10.4? Fully and particularly describe the invention. 10.4b, best mode of operation. So in such cases, the Act provides an option to the applicant to deposit the biological material at an International Depository Authority, IDA. as per the Budapest Treaty. As per Budapest Treaty, such deposit of biological material for patent procedural purpose is recognized. And you can deposit a biological material in any of the IDAs which are recognized by the countries. Such deposition should happen on or before the filing date of the invention. Once the deposition has happened, the details about the deposition should be provided in the specification. Now you may say the specification is already filed. How do I provide the details? And what kind of details are we talking about? So now think of it as a library where you need to go and search something. Similarly, here also you need to provide the name, address of the IDA, date on which it was deposited, and the number, a receipt number or a serial number which could identify the biological material in the library. Such details should be provided in the specification within 3 months from the filing date. And you are also required to provide the source and geographical origin of the biological material. Do you think we have such an IDA in India? Yes, there is one IDA within India at Chandigarh. It is MTCC, which is Microbial Type Culture Collection and Gene Bank. It's an important piece of information. You should remember it. Apart from this, there are other requirements also which we have already discussed during our discussion of section 7, where in case the inventors are not applicant, then a declaration has to be provided by the applicant that as per my knowledge, such and such folks are the true and first inventors. What form do we use for it? Form 5. So section 7.3 had already told us about it. We are revisiting it here again because as per section 10, the requirement says that while filing a complete specification, a form 5 should be filed, declaring that such and such folks are the true and first inventor. If you are not able to file at the time of filing the complete specification, within 1 month from the filing date, you need to file the form 5. During our discussion of section 9, we talked about a provisional specification can be converted into a regular specification within the time frame of 12 months. And the content of regular specification should be fairly based on what was disclosed in provisional application, isn't it? Now this section, subsection 10.7, provides an option which says that we understand that there could be modifications, there could be further developments with respect to the invention that was disclosed in provisional application. So you are allowed to have claims, subject matter pertaining to such developments or addition to your earlier invention. And you can file further applications. This concept is known as patent of addition, where the priority date is taken back. We will discuss about patent of addition when we get into the episode of discussing types of applications. So with this, we have our application ready. Form 1, 2, 3, 5, power of authority or power of attorney, Form 26, and our specification, which is in compliance with the requirement of the Patent Act. What next? Time to file the application. Visit the patent office, not literally, visit the website and make the filing. Make the payment, make the filing, and obtain the patent number. After this, patent application goes into the second phase of its life, where it goes through various stages within the patent office. We will discuss about the life of a patent application within the patent office in the next episode. Till then, take care. Have a good one. Bye-bye.